Go. All right, with the recording in progress, first, thanks all of you for jumping in. Wanted just to remind you that this is a discussion that occurs for the Legends of Real Estate for agents from the Legends of Real Estate. If by chance you are not a member of the Legends of Real Estate and have come upon this video, please note that these discussions are solely for the agents that work with the Legends of Real Estate. So that's my disclaimer, my disclosure. All the discussions are to remain with and feel comfortable with the Legends of Real Estate agents. So I'm going to go ahead and share my screen. I did want to go over just some of the changes that have occurred on a couple of the forms. Fortunately, it's not huge. And let me just make sure we've got the right screen up. Okay. Right. Yep. Go over to here. Okay. Stop sharing that one. And share the other one. There we go. All right. So you guys should see the as-is residential sale contract in front of you. Everybody see that okay?
Yes.
Okay, cool. All right. So the changes that occurred on the first, there were really only four forms that were changed. The as-is and the standard. And those two things, the changes that occurred on those two forms are exactly the same. So we'll review them on the as-is. There was a CRISP, that's the contract for sale and purchase for residential. It's a Florida form, not a Florida Realtor and Florida Bar form. We don't use that form, so we'll review the Condo Rider changes that occurred, Addendum A, very minor changes. Fortunately, nothing major on any of these updates, mostly to accommodate the premise that everything needs to be separated out, buyer and seller. All the items really should be separated out, buyer versus seller. As we go through the as-is, I do want to highlight a couple of things that I'm noticing that we're seeing come in and out with offers that come in, as well as just reminders when you're sending an offer out, pieces that you want to take a look at, and also things you want to be aware of. So let's just pop right into the as-is contract for sale and purchase. And this is not a change, just as a reminder. The binder, I know it's a little different on the purchase and sale agreement these days because you're putting the purchase price at the top rather than at the bottom, which was the NIFAR contract. So you're starting with the purchase price and then you're subtracting out all of those different items. On the binder, please be careful. It's kind of been a little confusing, I think. A company's offer, what this means is if this box is checked, so this is all the way to the left, if this box is checked, that means that the binder was already given. So it would have been needed to be given to the title company or whoever will be holding the binder. Does that have to be the same person as the escrow agent? Yes, it does. Does that have to be the same person that's closing? No, it does not. A buyer can choose to have their monies held at whatever attorney, title company, any other location if they would like, as long as it's acceptable to the seller. It does not have to be held with the company that is going to do the closing. So for example, if you're using J. Riley Williams for your closing and the buyer, and you're the listing agent, and the buyer makes an offer and the buyer wants to have the monies held at Landmark, they can do that. It's not a problem. You just have to make sure as the listing agent that the monies get transferred in a timely manner to wherever the property is closing so that they appropriately get credited for those funds and that those funds are available for the closing itself. Within 3 days, if left blank, or whatever number of days you put in this space here would be the number of days. And please remember the counting of days starts so that if we were to go under contract today, Tuesday, tomorrow, Wednesday is day one. So if it were 3, it would be Wednesday, Thursday, Friday. And this does not have, this purchase and sale agreement or contract for sale and purchase does not have an end time unless you've established one by putting it in to paragraph 20, or if it's for a specific item to get acceptance. Or even here, if you would like to have a binder deposited by a certain time, you can add that into this paragraph. But the number of days starts tomorrow. Tomorrow is day one. And if you leave it blank, it is 3 days. Again, does not include weekends or federal holidays. So if it we went under contract tomorrow and it was 3 days, it would be Thursday, Friday, Monday is when the binder would have to be deposited.
Thursday's
There's a
a
little,
federal holiday.
I'm sorry?
That matter? Never mind, never
If,
mind, never mind. Never mind.
no, it's a great question. If Thursday was a federal holiday, does it matter? No, it does not matter. It starts counting. It's if the timeline ends on a Saturday, Sunday, or federal holiday is when it would move to the next non-Saturday, Sunday, or federal holiday. So if day one is a federal holiday, like for example, if you went under contract on December 24th, day one would still be December 25th. Good question, though. Good clarification. Something that is new and different is under the financing section, the dollar amount or percentage. We're used to, from the NEFAR purchase sale agreement, writing in the loan amount here. For example, if it were an 80% loan on a $200,000 house, loan amount would be 160, right? I think something like that. You can also write in the percentage. This will avoid you having to change or amend the amount that they bring or the amount that they get a loan on. So if you get a pre-approval and the amount is for 80% and you want to leave it at 80%, that will always mean that it's 80%. If you put in an amount like 160, you would have to change that amount if you change up here the purchase price through negotiations. So that amount would have to be changed unless you use the percentage. That is a nice option, especially with VA loans. You can write 100% financing in here and then it will always remain the same, 100% financing. Please remember, even with 100% financing, that doesn't mean that a VA buyer doesn't or shouldn't consider a binder.
Clark, what's the vast majority of people use? Is it a percentage?
I'm sorry?
What is the vast majority of people that you see on these contracts use? Is it a percentage or a dollar amount?
Lately, it's been a dollar amount, but I think that people, if you're looking at contracts or offers coming in from agents who have been using the Florida Realtor documents for some time, it's most frequently a percentage. If you're looking at offers that are coming in from agents in our market area that are adjusting to the Florida Realtor documents, it's most often a number.
Clark,
So we're in a transition period. Yes, ma'am, Jerry?
if we are going to put a percentage there, won't we still have to deal with line 42?
With line 42, sure. What they're bringing to closing.
Right. So either way, we're going to have to make a change somewhere, or an amendment somewhere, whether it's a percentage or dollar
amount. If the price changes, sure, absolutely you will. You just won't have to change that line. What I'm finding is that people are making changes in specific items, so it will make change in the price, but we'll forget about the other items. This gives you that out to not have to make a change on this item. You would still, you're right, still have to make a change on what they're bringing to closing if the price changes.
Thank you.
Yeah. Anything else that you're seeing that you want to bring up? Okay. Time for acceptance. I'm getting a lot of questions on time for acceptance. So for example, if someone puts in, you receive an offer or you write in here that you want to have the acceptance by a certain time and it's on a certain date, excuse me, a certain date and a certain time, you can put both of those in here. If you don't have acceptance by that time and date, then this offer is deemed withdrawn. Does that mean it can't be resurrected? No, it's the same thing that the NEFAR contract had, that it was withdrawn. Either party could resurrect the offer, even if it has been withdrawn. You can still request for a new offer, or you can extend the time. Does the time to extend to respond have to be in a formal form, like an amendment to the contract? No, you can do it in an email where all parties are agreeing to extend the time for acceptance. Not the best way. Best way is to make sure you make a change and have all parties' initials so they're all in agreement. But if there is an email chain that goes back and forth extending the time to get under contract, that is sufficient to hold both parties to an agreement. But if the time expires and the seller wants to resurrect it by sending the offer back to the buyer, the seller can do that. On the forms, you'll see the 4 forms that came out as of the 1st. They are going to have the 12/24 date. So you see that at the bottom of all those pages. That's how you'll know that that's the most recent one. We have included that in all of the packages in app files. So please try to remember to grab a package. I know that I've heard back from people, oh, but if I grab a package, there's a lot of things I don't need, so I have to break them out. I get it. I understand that's a challenge. You can break out or split forms all at once that you're not going to be using, or that you're going to be using later. But the package is the best way to know that, or to get in line with all the forms that we're expecting, as well as making sure that you have the most up-to-date forms. There are no old forms in app files, so if you pick a form individually, it'll still be the most recent form. Closing shall occur. This would be the on or before date. Can you say on or before? Yes, you can say or before and a specific date. Shall occur on. If you leave it at that, that's the date that's expected. It depends on how you want to work with that. We've had a lot of questions on that. Coming on down a little bit further, assignability. This is different. I just want to make sure because there have been a couple of questions on this. On the assignability of the contract, if no box is checked, then the buyer may not assign this contract. This is different from the NEFAR contract. The NEFAR contract, it said that if no box is checked, then they may assign it but still be held liable. This is saying the buyer cannot assign it. So just a slight difference. I see some of you looking to use the defaults more regularly and not fill in blanks. Not a real proponent of not filling in blanks and not checking boxes. It's easy to get things missed. So make sure that you're able to clarify and be clear on what your offers look like and what your sellers are countering when they counter a process. Again, in the financing, see paragraph 2C. So if this relates back to if you put a number or a percentage in there. People are filling this out with a certain number of days. You're going to need to know your timeline. If you leave it as a default of 30 days and you're trying to close quickly, make sure you know, because if we have a contradiction in when loan approval is supposed to occur versus when closing is supposed to occur, it could cause a conflict in the contract. I'm seeing that come up a little more. We had kind of resolved that by changing it to 30 days in the NEFAR one, but based on some of the timelines in the Florida Realtor one, if you're leaving this at 30 days, please just make sure you check the timeline. Identifying the type of financing, also important. And then you can identify fixed or adjustable. Otherwise, it's going to be the going rate and whichever they choose or whichever is most acceptable to the buyer. So the buyer may make application within a certain number of days, 5 days if left blank, using good faith and diligent effort to obtain the approval of loan meeting the financing and appraisal terms. So appraisal terms of paragraph 8B1 and 8B2 above, which is loan approval, within the loan approval period and thereafter. So they have to do everything they're supposed to do, not just within the loan approval period, but everything that comes after it, all their responsibilities after the loan approval or after they get that loan approval. And they do have to, and this is slightly different, the buyer shall, upon written request, keep the seller and the broker fully informed. So there's a few more things that you need to be doing when it comes to ensuring that the process is moving forward. So if you have a listing and you get the offer and you want to make sure that the buyer has made their application or that where they are in the process or what is, we need to be making written requests of the other side. You can make these requests to the buyer through the buyer's broker, buyer's agent, but we do need to be making sure that we have a way to edify and are requesting updates from the other side in writing. You should be doing those through app files so you have a record of them. And the responses, you'll need to make sure that they're either reply all or forward the responses into app files. But it's slightly different. You could make calls. You can still make calls to the lenders and all of that, but the contract specifically states that they have to provide the information upon written request. If within the loan approval period, the buyer obtains loan approval, the buyer shall notify the seller. So if they get loan approval, they're supposed to notify us. So they would be notifying the seller through you if it's your listing, or if it's your buyer, you would be responsible for making sure that the other side is aware that the buyer has received loan approval prior to the expiration of the loan approval period. The seller may elect to terminate the contract by delivering written notice of termination to the buyer within 3 days after the expiration of the loan approval period. So if we haven't received information back, we've made the request, excuse me, we made the request and it's the end of the loan approval period, we haven't received information back, the seller can go ahead and cancel the contract. If the buyer's in default, then of course they would be responsible for or allowed to keep the binder. On to I'm sorry, was there a question I missed?
No, Clark, I was going to ask on some of those there when you're asking for information about the loan or process and approval, is there certain language that we need to be specified when we're dealing with other agents on what we can ask or what we cannot ask?
So if you're on the listing side and
Yeah.
you're making requests of the buyer, they should go through the buyer's broker, the buyer's agent, and they should all start with seller requests. Seller requests. On behalf of the seller, we request an update on loan approval. On behalf of the seller, we request, or the seller is requesting an update on, or the seller requests a clear to close, or the seller is requesting, or on behalf of the seller, we're requesting. I know that this is a really, may seem like a very minute element, but our words really matter right now. We're being shopped regularly. The DOJ continues to look for opportunities to say that we are not following through with the agreement and settlement. Lawsuits continue to be filed. We don't want to see your name or our name on any of them. So please, while it may seem minor, really try to keep the communication that you facilitate, whether it's single agency or transaction brokerage, and we're a transaction brokerage company, keep the language as the seller is requesting of the buyer, or the seller requests, or on behalf of the seller, we are requesting. The transaction, the big thing with this DOJ is that the transactions need to be between the buyer and the seller. Does that make sense?
Mm-hmm. Yep.
Okay. One of the changes that did come up is they separated out in paragraphs 9 and 10. They were very specific about the seller pays for the seller closing services and the buyer pays for the buyer's closing services. So if there are any fees that a title company is charging that are for the closing, and they are trying to attribute one of those or some of those to the seller and some of those to the buyer, this is where it indicates that the buyer is paying the buyer's fees and the seller is paying the seller's fees as it relates to closing services. If the buyer has requested concessions in any format from the seller, and maybe they requested the flat amount, $20,000, can some of those monies be used for these closing services? Yes, they can be. So just like before, if the buyer was requesting $5,000 towards their buyer closing costs, now it would be that the buyer is requesting $5,000 in concessions. Previously, if it were the buyers requesting $5,000 in closing costs, the title company would take that $5,000 and go check, 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 check. And when they ran out of money, then the remaining costs would be attributed to the buyer. This is saying that the seller or the buyer's closing service fee would be one of those items, very specific, one of those items that a concession would be applicable to. So they want to make sure that it's broken out, buyer versus seller. This is that whole decoupling that we're looking at. Did want to point out in title evidence, if left blank, then 15 days. If paragraph 8A is checked, then 5 days. So in the Florida Realtor contract for sale and purchase, they make a differentiation between a financed property. And remember, we had 10 days prior to closing for title evidence in the NEFAR one. It is now 15 days. and that's for a finance property, and 5 days for a cash transaction. So that it would be 5 days before uh, before closing the title evidence would be needed. So notice the difference between a finance property and cash. Another recent addition.
Clark.
Yes, ma'am.
I have a question. In the case when the seller is going to give to the buyer, like in my case, my seller is going to give $20,000 to the buyer to fix the septic tank. Do I need to put that, they need to put that 20,000 in seller's closing services? Or this is different?
You wouldn't have to put it in closing services. Closing services would be fees that the title company or the closing company is charging. You're talking about a concession. So the concession is $20,000. So if the buyer asks for assistance with their buyer's broker, in addition to the $20,000, you would use Form FF, and you would be able to identify a specific percentage that your seller may be willing to contribute to the buyer's broker, as well as the $20,000 or $15,000 or whatever amount it is that they establish based on the negotiations of what they will be paying as it relates to the septic. So you can identify both a percentage and an amount in Form FF.
Okay, okay, perfect. Thank you.
Yes, of course. And that brings up a really good point. We really need to be focused on concessions, not commission. Concessions, especially if a buyer is requesting a certain amount of concessions, and they have the right to use those concessions however they would like, we really need to specify that through Form FF, because if you put into paragraph 20, the buyer's requesting the seller pay $20,000 in concessions. If the seller is unaware that some of those monies may be used for their buyer broker agreement, then that's a violation. That's exactly why Form FF was created, because in Form FF, it states that the seller is providing X amount of money or X percentage of money or a combination of the two, and the seller understands that some of the monies that they are offering or that they have agreed to pay may be used to satisfy a buyer broker agreement that has been executed outside of the contract. And that was one of the things that came up in the court case, is that sellers were indicating that they had no idea that some of the monies that they were paying the listing brokerage was going to pay a buyer's brokerage. So that they stood very hard on that, and it was a very pivotal piece of evidence, or pivotal piece of disclosure, pivotal piece of statement, I guess, a pivotal statement that brought the case to where it is, or where it came to. That
Clark, I have a question.
Sure.
On my Atlantic Boulevard deal, the buyer is paying half of all the seller's closing costs. So the seller is paying me a certain amount of commission. So the buyer is paying half of that. But I don't need to have a compensation agreement with the buyer if he's paying everything, half of all the seller's closing costs, right?
Yes, you do. You always have to have a compensation. You always have to have a buyer broker agreement with the buyer. You always have to have that. You also have to have a compensation agreement, which is outside of the contract. Compensation agreements, and you'll see when we get to paragraph 19, they've made some changes to paragraph 19 to add addendum FF and addendum GG into the contract, which is a good thing, because now you don't have to write it in. But you'll notice, and when we get to paragraph 19, is that they have not added compensation agreements. Why? Because compensation agreements are either between the seller's broker and the buyer's broker, or the seller and the buyer's broker. None of those parties are not the parties in this contract. The parties in the contract are the buyer and the seller. So
But
in
my
your
buyer
case,
the buyer doesn't have an agent.
well, the buyer, if the buyer doesn't have an agent, then who's representing the buyer?
His lawyer.
Okay, that's fine. So the lawyer has written the offer, correct?
Yeah, yes.
And you said that half of the money was coming from the buyer and half of the money was coming from the seller.
Right, the seller, the
For
buyer is
closing
paying
costs.
half of all the seller's closing costs,
The
which
buyer is paying all the seller's closing costs?
half of all his closing costs, yeah, which
Right. So
include the percentage of compensation.
right. So you would put that into the contract that the seller is paying half of all compensation.
Yeah, it's
Half
on the
of
contract. Yeah,
half of all, it would have it actually be that the buyer and the seller are equally splitting all compensation and concessions and
yes.
closing costs.
Mhm.
But you would still need okay, so if the buyer is being represented by an attorney, that's that agreement over there. You still need all of your stuff on the listing side for Atlantic Boulevard.
Okay.
Clark,
I can take a look at
hey
at all the
Clark,
forms a little
Yeah,
bit. Yeah.
I think what Ed is saying is that I'm going to use the wrong term, his compensation, his commission is part of the seller's closing costs. So that's
Yeah.
why, yeah.
Mhm.
I understand, but it's not. So commission is now part of compensation. Commission is now compensation. Compensation can be a part of concessions, but it has to be disclosed to all parties what the monies are being used for. So if you state in paragraph 19 that the buyer and the seller have agreed to split all closing costs, compensation, and concessions, you're covering yourself to make sure that you've got everything in there so that everybody is aware that everything is lumped together and then we split it out 50-50. As long as it says between the buyer and the seller they've agreed to do this, then you're fine. Does that make sense, Karen?
Absolutely. I was thinking that maybe Ed was saying one thing and it wasn't coming across. Yes, it does.
Okay, thanks for helping me get that to the right point. Ed, does that make sense?
Yeah, and on the contract on line 284 says, who pays what. On the seller side, it says on the bottom other 50% of all closing costs, including real estate commission, is what their lawyer wrote on the contract.
Okay. That's fine. That's
On,
fine. We
on
still
both
do.
sides.
I mean, we're finding we're getting, and this is where I'm going to ask you to please, give me a ring or whatever. Please don't start writing. I realize that this came from an attorney, and we can't control that, but please use the forms that have been provided.
Okay.
I'm not criticizing you, Ed. This is coming from an attorney. It was written by an attorney. That's fine. We're trying to get away from commission into compensation and concessions. I know it seems silly. I get it, but I'm trying to make sure that we're all kind of on the same page and protecting our fannies.
Understand.
Yeah. So, if and you bring up another good point, Ed, that this has been coming up more frequently. Buyers call and say, I want to see this property. Are you working with an agent? No, I'm not working with an agent. I don't want to work with an agent. I want to go directly to the seller. Okay, well, the seller has representation. If you want to go directly to the seller, you have to go to the agent that the seller has chosen to list their property. Great, fine. Here's the agent. Call the agent. You, as the agent, the listing agent, or any agent in our company with one of our listings can show a property without a buyer broker agreement. Why? Because you're showing the property on behalf of the seller. The seller is contracted with the brokerage, so therefore you can show it without a buyer broker agreement. If a buyer wants to go directly to the seller and doesn't want to sign a buyer broker agreement, that's fine. What we need to do is start talking to our sellers to ensure that they understand that if someone wants to come to you directly, how do you want us to handle that? Do you want them to come to me directly? Do you want me to meet with you and them directly? How do you want this? And the seller can say, look, if someone wants to come to me directly, I've hired you. And this is something else that we need to add to our value proposition. Here's I'm managing these individuals who are trying to go to you directly and waste your time.
Right.
The seller can say to you, look, if a buyer wants to go direct and doesn't want representation, that's fine. I don't care. But I'm not going to take an offer written on an 8.5 by 11 piece of paper that doesn't cover all the different elements. So just tell them that's fine. If they want to represent themselves, that's fine. Their offer needs to be on a legal form. So either by a real estate attorney, a legally binding document, most likely from a real estate attorney or from an agent. And if they don't want to use you, they can use whoever they want. But a seller can correct that they want an offer coming in on a legally binding form. We've had people go to the listing agent saying, well, if I just write it up myself, will you present it? We have to present any offer. That would be an offer. But as long as we've discussed it with the seller, what the seller is willing to evaluate, then we can be prepared and, with the permission of the seller, state to the buyer who's asking to represent themselves and write, $500,000 closed in 20 days on a piece of paper or a cocktail napkin and ask us to present that. We can say, great, that's fine, represent yourself, but here's the deal. The seller has requested that any offer be written on a legally binding document, which either comes from a real estate attorney or a licensed realtor. You choose how you want to make it happen. Because there's too many things that get missed. And then also you have to be careful of the liability with an individual representing themselves, how far you overstep. You're going to want to make sure that everything happens in a timely manner for the seller. So you're going to be making requests of the buyer who's representing themselves. But when are you crossing the line to working with the seller and now working with the buyer? And I think we're going to get into some challenges with that, is that we'll do things working with the seller and now the buyer comes representing themselves, and now we're trying to prod the buyer along to do certain things that they're supposed to do. Could we be perceived as working with them? So we got to watch that.
Yeah, that
Clark.
makes sense. Yeah.
Clark, I have
I'm
a
sorry.
question that's nitpicky.
Yes.
I apologize.
No,
You
no,
said
go.
you said either legally binding contract written by either an attorney or a licensed realtor. It could just be a licensee, correct? Doesn't have to be a realtor.
You're correct. You're correct.
Thank
It could be, it doesn't have to be a member of NAR. You are correct.
Thank you.
So it could be a real estate licensee, which is where we're going to get into some more challenges too. Yeah, because there are some brokerages that have pulled out of NAR, and there are some individuals who would like to pull out of NAR, and they are looking at, how do we, or excuse me, not just NAR, out of the local board, state, and national. So
Thank you.
Jerry's correct. It could be a licensee, anybody with a real estate license, which is scary all in itself. Good point, though.
Thank you. It happens.
But they don't have
sometimes.
to. The seller could say a licensed realtor, and then it would have to be a licensee that's a member of our board. Here's the other thing that we're going to get into is if they are, to Jerry's point, if they are a licensee, in other words, an individual holding a real estate license, they do not have access or are not able to use forms created by Florida realtors. So if they then present an offer on a form that's written by Florida realtors, that's an illegal use of those forms. So if it's a licensee, not a member of the board, not a member of NAR, not a member of Florida realtors, then, and they're using Florida realtor forms, that's an illegal use of those forms. So we have to just keep in mind all the different scenarios. Whee!
So is that up to us to check that they're a realtor, not a licensee?
Yeah, it would be. It would be our responsibility to ensure that they have the rights to utilize the forms. Most in our market, most of the brokerages, I can't think of one actually right now that is not continued to be a member. It's some of the individual brokerages, maybe one or two or three people that have elected not to remain a member of the board. And so I would probably be more concerned about the smaller brokerages when you receive an offer.
Clark, I have a question. In the case, because I am receiving a lot of offers from investors, but the offers are just email offers through the email, but no with a form, with the regular form that we used. If they are not realtors, how will be the offer that they submit to us? Do I need to make the offer and they need to sign the offer, or how that works?
Well, it's a
If it's
when it-
approved for, if it's because at the beginning they sent me emails, right? I am offering this amount. If my seller, she said, oh yes, this is a good offer, do I need to fill out the offer for them, or how that works?
So if your seller is, if you receive an email, it's somewhere between verbal and written. I mean, it's written on an email, but it's somewhere
Yes.
between verbal and written as to how solid it is. You have an obligation still to present that to your seller. But if someone just says, I'm offering X number of dollars, I want to close in 30 days, I'll give you a $5,000 binder. There's a lot of pieces that are missing. When are you doing inspections? How long do you have for inspections? Are you doing this as is? I mean, there are a lot of different things that are still missing. So if your seller is saying, I'd really like to pursue this, your best bet is to go back to that individual and say that the seller is interested in pursuing your potential offer. How would you like to formulate this offer? Are you going to be executing it through a realtor, a licensee, an attorney? Are you asking me to do that? If they're asking you to do that, you are then working with them and you need to have a buyer-broker agreement. And we've run into this with investors saying, I don't want to sign a buyer-broker agreement. I'm not interested in being represented. Well, if they're not interested in being represented, then they have to find their own format for presenting a fully executable offer.
Mhm.
Okay.
Are we okay to move on? Anybody else want to throw something out there?
Some investors will right away say that I'll let you write it up.
And that's fine. And if they do that, there's not a problem with that.
Right.
They have to be represented. I mean, you
Right.
have to have a buyer broker agreement at that point.
Exactly.
So you would need to have something that says that you can work with them.
Right.
Remember, we mentioned closing services, so they did make some changes here. Closing services shall have the meaning ascribed to the term in section blah, 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 of the Florida statutes. Each party shall bear their own closing services payable to the closing agent or such other provider or providers as each party may select. So this is now defining closing services for you as it relates to that change. The seller shall designate the closing agent and pay for the owners. Now this is, remember, where you can choose, the buyer or the seller can choose to pay for the closing agent and the owner's policy. The seller shall designate the closing agent and pay for owner's policy and charges. Buyer shall pay the premium for lender's title policy and charges, and endorsements, excuse me, and policy and endorsements. So that's the way it will be. It's shortened up. Same thing for the buyer will designate. Please, and Miami-Dade, fortunately, we don't have to worry about that right now. please note, there's a brokerage out there that is having their buyer take on the owner's title policy and the closing agent, in part because they have a vested interest in both of those. We have had a lot of challenges with the three most recent offers that we've received from that brokerage. Remember, this is all of us just talking Legends of Real Estate. So the brokerage was the DJ Lindsay. Was DJ Lindsay. So they add things to paragraph 19, which are clarified in Form FF, and they've been having the buyer pay for the closing agent and the owner's policy. And we've had problems with 2 of the 3 transactions where this was occurring, and it's problems with the closing agent. And in one case, it's a lender that's connected to that company also. And we're having some issues because the lender is not registered. So just be aware that you know, if the seller wants control of their transaction in this manner, that's fine. If they want to pass it off because they feel like the offer is stronger with the buyer paying, that's great. Let's look at all terms and conditions and find out what negotiation opportunities might exist and make the most sense for the seller and the buyer in the transaction. One thing that I'm noticing is getting missed a lot is the home warranty. At closing, buyer, seller, or it's not applicable for home warranty issued. Home warranty provides replacement, blah, 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 blah. There's not an auto fill in for this, so please don't forget to fill that in. Special assessments, not any changes really there. Disclosures, these are all the disclosures we need to provide to our buyers if we're writing this up, where it's related to permits. Permits are included in here. I've seen a couple people put in permits in paragraph 20 for additional terms and conditions. The closing of permits is already covered in the standard disclosures. Mold, flood zone, please don't forget the energy brochure. I know you look at me funny when I ask you, just please email the energy brochure. The energy brochure does not have a place for your buyer to sign or initial unless you set it up to have that. I just need to know that you've sent it to them or they've received it. So when you're submitting the brochure to the checklist, it's indicating to me that you've sent it, hand delivered, or emailed it to the buyer, and that they've been given a copy of the energy brochure. We are required to give it to them. They're also
Clark,
required to give it. Yes, sir.
question. This has come up a couple times. All these disclosures, I know that the Legends has put together these nice packets for when we go to sell and buy a home. Is there a pamphlet or a one-page document or anything that we can share that would cover us, that the Legends can create and say, hey, look, this is going to cover us all on ours, that we can just send? That way it kind of covers all basis of the sales and hit all of these instead of us doing it piece by piece.
Yes and no. So we currently have the multiple disclosure affidavit, which is specifically for buyers, and that makes them aware of certain things like the importance of having a home inspection, the importance of having a WDO inspection, those kinds of things. But we can't put together a disclosure that will cover the necessity to provide a copy of the energy brochure.
Okay.
Nor can we do anything different with the lead-based paint disclosure or the lead-based paint brochure. Those specific items have to be completed as well as provided. So we can, in our disclosures, we can make them aware of the importance of ensuring that lead-based paint doesn't exist in a property, but we still have an obligation, a federal obligation, to provide the lead-based paint disclosure and the lead-based paint brochure. Same thing with the Florida statute related to the energy brochure. So I don't know that a disclosure will allow us to not have to provide those documents.
No, I was just looking for a simpler process. That's all. But okay,
yeah.
Very good.
Yeah. No, I doubt that And as a matter of fact, we're probably going to make it more difficult because or more challenging because we are putting together a seller's disclosure as well as it'll actually be a company disclosure that covers things for both sellers and buyers, just to ensure we've made everybody aware. Seller's disclosure, different there, property maintenance. Inspection period, still a little confusion on the inspection period. This is the as-is purchase and sale agreement, which is the predominant document that we would like everyone to be using, in part because this continues to separate and supports the separation between buyer and seller. Also, within the inspection period here, it indicates that the buyer will have 15 days. I know a lot of us have been working for many years on 10 days for inspections, 7 days to negotiate repairs, and 3 days after that the buyer has the right to remove themselves. In the Florida Realtor contracts, it is 15 days or whatever amount of days is filled in here in this blank. That's the amount of time that the buyer has to evaluate the property. In the as-is purchase and sale agreement, during that period of time, that 5 days, 15 days, 10 days, whatever it happens to be, that's the time that they can walk away and say, I don't like the house. Can they still ask for repairs? They can. They can still say, look, we found something we weren't aware of, or that we didn't know, or that is a little more than we wanted to get into. So what I'd like to do is ask, are you willing to help with that? They can ask. But this is the as-is contract for sale and purchase. It establishes no obligation on behalf of the owner, the seller, to make any repairs whatsoever. So putting into paragraph 20, properties being sold as is somewhat redundant. If you add the as-is addendum to the as-is purchase and sale agreement, that's somewhat redundant. So we just kind of need to make sure that we're all on the same page. It's 15 days or whatever number of days is in here for the buyer to evaluate the property and decide, do I want to move forward? Do I not want to move forward? And if they want to move forward and there's still time in their inspection period and they want to say, will you help me with this? And the seller says, yes, I will, then great. That's something that you add on to the contract and an addendum to the contract, which I don't know, which is still called an amendment. No, an addendum in the Florida Realtor world.
Clark,
Yeah.
for the investors, when they say, in the offers, they say assist. So when they say assist, can we in the line proper inspection, can we put just 0 days? Or even that we have to put 10 or 15 days? Or can we put just 0 because they say assist? They are not.
Well, this is it. You're talking about two different things. This is the amount of time that they want to evaluate the property. It has nothing to do with whether they want to ask for repairs or not. So if you put 0 days in here, you're giving them no time to do inspections. Most of the inspectors that I've seen write email offers, they include a time like 5 days or 7 days to do inspections, and that's what would go in here. The offer itself is an offer. This document itself is an as-is document, which says, paraphrasing, I, the buyer, am making an offer to you, the seller, and I'm making it in an as-is format. I don't intend to, at this time, make any requests for repairs. That's this document. If the buyer wants to set themselves up to have a predetermined amount the seller commits to, that would be the standard contract for sale and purchase. There's an element in the standard contract for sale and purchase that says you're going to give either a percentage or a dollar amount towards repairs, towards WDO, towards other items. Those are already lined out in the standard in the standard contract for sale and purchase. The as-is does not contain any of that. So you're talking about two different things. How much time do I have to evaluate the property versus am I taking the property as is or not?
Oh, okay. Yeah. Thank you.
Using this form confirms that they've elected to take it as is if they choose to move forward after the inspection period. But some investors may be interested in a zero inspection period and just be ready to close. So that is, you can this number be zero? It can be zero. Does that make sense to everybody?
Yeah.
The as is, it's as is. If they want to try and make a request for repairs during that inspection period, they can. The seller has no obligation to do anything.
Does this still have the 7 and the 3 like NEFARS does?
No, it does not. Everything is included in the 15.
Oh,
It's an as is. If you're using the standard, there is a time frame in the standard related to inspections, negotiation. That's the standard. In the as is, everything is within 15 days. This is when you
Okay.
evaluate the property as the buyer. This is when you say, I'll take it. This is when you say, I won't take it. This is when you say, I'll take it, but I'd like, all within the 15 days. Can the 15 days be extended? Yes, the 15 days can be extended as long as all parties agree. Permits are covered here also. Discussion of the escrow agent. Thinking this was, oh no, there was this default. All right, so there's a slight change in the default. The current listing agreement states that, and it's filled in, we've asked, our default is 50%, that if the seller retains any of the deposit, the buyer's deposit as liquidated damages, the brokerage is entitled to 50% of that. The way that the Florida Realtor contract was written was that the selling brokerage was entitled to 50% also. And that's been removed from here if the buyer defaults. Under dispute resolution, slightly different. So just kind of, if you've got a binder dispute, remember, we don't have an escrow account. So if your buyer's money is held at a title company, we have to follow the guidelines of the title company. Most title companies will encourage buyer and seller to negotiate, and then if within a certain period of time the buyer and seller haven't come to agreement on the disbursement of those funds, that they turn them over to the state. The contract calls for the buyer and the seller to have 10 days to negotiate that binder, and then the buyer and the seller shall attempt through mediation if they can't come to an agreement. So it's first mediation, then arbitration, which is the further down paragraph. So just note that it's customary for even if it was held at a brokerage, that Florida Realtor, as is contract for sale and purchase, gives the buyer and seller 10 days to negotiate first. So you would be facilitating that. And then if you can't come to an agreement, going to mediation. And mediation is available through our board. Residential. So you can see not many major changes, only things to facilitate the decoupling of everything, and buyer versus seller, or buyer and seller items. Here are these standards that, access, risk, 1031 exchanges, waivers, riders, addenda, all that kind of good stuff. And then we do get to paragraph 19. So what happened is the reason this looks so messy is because all they really did was add FF and GG, but it adjusted the paragraph, so they had to remove some and add some. But really all it did was add FF and GG here. Just move things around a little bit. So remember, FF is the credit. So that is the document, the addendum that states that the seller is providing some monies to the buyer, and the monies that the seller is providing may be used for the buyer's broker agreement that the buyer has entered into outside of the agreement between the buyer and the seller. Still, no compensation agreement. Why? Because the compensation agreement is an agreement that the brokerage needs to use in order to ensure they get paid. I'm sorry, GG. Please remember GG, the seller's agreement with respect to the buyer's broker. This is to assist in ensuring that the buyer's broker gets paid. We as realtors are there to facilitate the negotiation, we can't slow the negotiation down in order to ensure that we get paid. But the buyer can. The buyer can say, look, I need to know what the seller is willing to offer me to help with my buyer's broker agreement, because that can impact what I can afford, how much I can afford, what I'm willing to pay, other negotiations I may have. So GG says, look, if a compensation agreement has not been edified, has not been signed off on, so that I know as a buyer what the seller's willing to pay, even if it's zero, then I have 3 days or whatever number of days you put into GG as a contingency, saying until we get that executed, I'm still negotiating my terms and conditions. Or if we don't get it executed within a certain number of days, 3 days is the default, then I'm going to walk away until I can figure out what the seller's willing to do. Remember, the buyer would still already have a buyer's broker agreement, which says what their commitment is to the buyer's broker. So all we did here was add FF and GG, move things around. It looks messy, but it's not so bad.
So because it looks messy, Clark, sorry, you had given us a little cheat sheet. I don't have it in front of me as to which addenda was required with in certain scenarios. Does this change that cheat sheet? And if so, are we going to get a revised one?
It shouldn't change the cheat sheet. I'm pretty sure I had FF and GG on there, but I'll check it.
Thank you.
Yeah. And thanks for remembering there was a cheat sheet.
Where is
Under additional terms and concessions, or additional terms, I did want to just kind of go back to the wording, please. In most cases, we're recommending using FF. If the buyer is not asking for anything other than assistance with their buyer closing costs, then you can put in something to the effect of buyer requests seller to pay X number of dollars in concessions towards buyer's closing costs. Or if they're only requesting assistance with their buyer's broker, you could put in buyer requests seller to pay X% to buyer's broker. And then you wouldn't have to have FF. You would still need the compensation agreement, because the compensation agreement is between the seller or the seller's broker and the buyer's broker. You would still need that compensation agreement, but just wanted to kind of remind you, please try to think about the words being between the buyer and the seller, because that's one of the other places that we're getting scrutinized. We're very used to writing seller to pay $5,000 towards buyer's closing costs. I get it that it's assumed that the buyer is requesting that. But if we could please start adding buyer requests, or at the request of the buyer, at the request of the buyer, the sellers, the request of the buyer, we are requesting that, or request of the buyer, I'm tongue-tied. But if we could just focus on buyer requests, seller, that would be really helpful.
Clark, I'm sorry. I'm just going to go backwards for a second. I apologize. I think I heard someone ask. Thank you. I think I heard someone ask where they could find the cheat sheet for the addenda.
For the addenda, I think I put it into the company documents, but I can check that too. On app files, the company folder. Or it could be in the, I think I created a folder for NAR also. Settlement.
Thank you.
I'll look.
Thank you, sir.
Yeah.
Can I ask a question on the whatever it was, 20, I think? I just want a clarification. We have to use the word concession on the first, as an example of the first part, because the buyer's requesting the seller to pay the buyer monies and the buyer can't get compensation. So that's why we put the word concessions.
I'm not sure I understand the question.
I'm just trying to understand why that word concessions is in there, not compensation. And I'm thinking it's because you can't pay compensation to a buyer. So in order for them to get any monies towards paying us, we have to use the word concessions. Is that correct or not correct?
It's sort of correct. Concession is used to cover pretty much everything. So concessions can cover compensation. Concessions can cover closing costs. Concessions are the seller paying monies to the buyer. The challenge is if the seller, for example, and there's, you may not be able to see, there's 3 dots after concessions. If this were solely for the buyer's closing costs, we would want to say the buyer requests seller to pay X number of dollars, $5,000 in concessions towards the buyer's closing costs. So any amount that a seller pays to a buyer, any amount that they give to a buyer are considered concessions. Can compensation be a part of concessions? Yes, they can be. However, if concessions are going to be used for compensation, the seller has to be made aware that those monies may be used to pay a buyer's broker. That's when I would rather we use Form FF. So if we're saying buyer requests seller to pay $5,000 concessions towards buyer's closing costs and prepaids, you could say that here, which would suffice. And in that case like that, then they would not be paying anything towards the buyer's broker. If you use FF, you could ask for concessions as a lump sum and say, okay, the buyers in FF, you could put in $20,000 and FF discloses to the seller that of those $20,000, some may be used to suffice or to go towards a buyer-broker agreement that was executed outside of the contract. It's just that all parties have to be aware.
So that extra verbiage cannot be detailed in this paragraph. You have to use FF.
It should not be detailed in this paragraph. It should be used in FF because FF places all parties on notice. Otherwise, you're starting to act as an attorney by putting all of that additional information in here when the form exists already. So I'd much rather we use the form than try and write that all out into paragraph 20.
Okay.
The attorneys have put that form together so that everybody's put on notice. If you're just asking for concessions towards their closing costs, you can put that in here. I would still prefer that we use FF in any situation where we're asking for monies from the seller, because it's very clear in FF that puts all parties on notice. I'm asking for monies, or I'm asking for a percentage, or I'm asking for both. I get to decide, the buyer get to decide how those. But I've seen a lot of people using seller to pay X% to the buyer's broker when it really needs to be buyer requests seller to pay X% to the buyer's broker. If that's all you're asking for and you're not asking for assistance in closing costs. It's when you start to mesh them both together that we run into challenges and writing too much. Did that answer your question, Anthony? Or is that clear as mud?
Yes.
I didn't know that it was an FF, and maybe FF is new. So in my last contract, it didn't have it broken out, but I detailed it very specifically. So that's why I was asking.
Yeah. Anybody else want to? We've termed FF a frickin' form, but all the other things too. But it can be our friend, I promise. You know, I mean, many of us have worked together a while. You'll know that I'm not a big proponent of scratching things out, and I've had to change my mindset. So if you are scratching things out on a document, please make sure as a part of that everyone is aware that there's a counter that exists, that you check that box to ensure that they're either looking at what's here, or if you've created an amendment to the contract or an addendum. I don't know why they don't do amendments, but there's addendum to the contract. I think
Hopefully they change it after I submitted my thing.
I know, hopefully. Also, it would be lovely. Just the other notice here on broker listings and cooperating brokers of any name below, collectively broker, and we don't have all that other information here. So we need to change our closing instructions. Are the only brokers entitled to compensation in connection with the contract, instruction of the closing agent, seller, buyer, direct, blah, 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 agreements between, except has retained such fees from the escrow funds. This contract shall not modify any MLS or other. So we've removed MLS or other because remember, compensation is no longer included in MLS. So that's the reason that was pulled out. And that's kind of some of the, I mean, minor, not very many changes and very minor just to facilitate the decoupling of everything. I went over a lot of other things that I'm still seeing, that I'm starting to see consistently just to kind of make you guys aware of things that I'd like to see us doing better. And to hopefully clarify maybe some questions that you have on the as-is purchase and sale agreement, contract for sale and purchase, excuse me. Is there anything else anybody on this
Yes.
form wants to bring up? Yes,
Please.
Anthony.
It's actually what you and I had discussed last week on the personal
Yeah.
property section. And I want to bring it
Yeah.
up because there was the 15 agents on here that I think should need to know the conversation we had because they can be affected. That word if is missing. How can we help ourselves not be liable or responsible that somebody doesn't come along and say, oh, it doesn't say if those things exist. So that means you have to pay for a dishwasher because it's in this contract. So how can we agents protect ourselves if the word if is not in here? Are we allowed to put the word if in here? Because that's what I'd like to do.
Under, what are you doing? Talking about
On the
putting it
personal
under
property
paragraph?
at the beginning, the very beginning, first page. Well,
What are
we
you
had
talking
talked
about?
about, I know
No,
the addendum,
yeah, because there's so little space for it.
page 1.
Yeah, you can. So what Anthony's saying is that
Line
in here, it
15 and 16.
so it doesn't say that if it's existing. It's just saying unless excluded or by other terms of the contract, the following items which are owned by the seller and existing on the property. So the premise from the legal hotline is that if it's not supposed to be there, it should be under excluded items. Anthony's position is, well, if it's existing on there and it's staying, it doesn't include the term if it's existing. So you can't change that here. The only thing we can do is be more specific by identifying those items that are for sure staying. That's why we did the personal property checklist for the listing, or being specific here as to what the buyer is expecting until they make a decision on how they may want to change the wording. How would you add if to this? You're saying add if in the statement up here itself?
Yes. Because that's what NEFAR's had, and that is actually what your checklist that you have also has the word if.
Right.
But
Right.
say, for instance, a house does not have a refrigerator, a dishwasher, a disposal in it. This paragraph states that
Right.
it has a refrigerator, so you'll be liable possibly if the buyer purchases and closes and he finds out, oh, it doesn't have a refrigerator, dishwasher, and disposal. Well, the paragraph
Right.
says that it does, so now we agents might be liable to have to buy a refrigerator, dishwasher, and disposal. That's the word. That's why that word if needs to be in there.
So on line 16, which are owned by seller and if
If
existing
If they're
on
the
existing,
property.
yeah.
Correct.
Mhm.
Because right
And-
now, I bet you nobody else realizes that. And what I just said, that scenario could happen if a smart or smart ass buyer comes along and demands these items that might not be in the house because this paragraph says that they are in the house.
I would be very hesitant to add it here. I would really prefer that we exclude down here. So if it's
Yeah.
something if something is here that doesn't exist, it would make more sense to exclude them here until we can get them either to change this or you add the attachment of the seller check of the personal property checklist of what truly stays and what truly goes. The only other thing that may work would be to actually cross through something like a disposal or cross
Right.
through it.
That's just a lot of, well, extra work, but that's the only other way to do it is to realize that
Yeah.
you have to cross out.
Yeah, I mean, I think it's a good point. I'm hesitant to add language. I prefer that we take things out.
I,
Um,
I don't want
Go
to
ahead.
get anybody on your, I was told as long as we don't make it look like we are making it match the type and everything, as long as you make it totally clear that it's a change. I was told by, in our core law classes that we're allowed to make the change as long as we make it totally clear that we're making the change. Like put it really bold or circle it or something like that. But that's up to you. It's your company, so you have to decide.
Yeah,
Do it.
I'm just concerned. So where would you put if? I mean, how would you make sure that if is noted? Are you going to put it
I
up
would
here
put
with a
it in that space
line
up there, put an arrow and put it in the space right up above the word
here?
excluded. Yeah, that's where I would do. And put it big if, circle it and put an arrow down. That's how I would do it if it was me. And
Um, see, I I agree. I think that
it's a lot easier than having to cross off all these things. I mean, it's just putting the word.
it may be easier, but I'm still concerned about the intention. Even if you put it here and put a line, I'm still concerned about the intention and then the perception that we could be. I would prefer that you cross out items that don't exist.
Mhm.
If they don't exist, I would cross through them if you want to make sure that they don't stay. Um, or use the personal property checklist, reference personal property checklist for exact items. It's probably better just to cross them out. I'm concerned about adding words and then it not being clear where that word goes or it not being clear what the if is.
Can I then, if you use a personal property checklist, don't you have to then make that part of this contract somewhere?
Sure, you can add it right here. You can add it into either of these or to paragraph 20
So you're right in there.
or under paragraph 19 as a personal property checklist.
So you write it, okay.
Any of those. I mean, I know it's a hassle, but I would still prefer that the primary option would be cross things out if they don't exist. To be clear about what is not there or what is not conveying. Identify anything else here. Use the personal property checklist, which I guess I'd have to go back and forth on which would be more liable. We'd be more liable for using the personal property checklist or adding if here, because see, here's my concern. You put if here, you put it right here, and you put an arrow down to here. Now this gets saved and then it goes to somebody else, and now the arrow appears over here, or the arrow appears over here because it didn't save right, or didn't open right, or didn't didn't print right, or I don't know. I'm concerned that I'd almost like to establish an if statement for down here on these lines, with maybe some counsel or something. Let me see what our attorney thinks about it.
I wish they got my email before they redid these forms. I didn't realize they were redoing the forms at the end of the year.
Yeah, well, I know they started redoing them long before our discussion, so. All right, thanks for bringing that up. Is there anything anybody else wants to bring up about the as is?
Nope.
Okay. The other thing that was changed was the condo rider. Very briefly, they removed the word condominium from the association approval. So it could be any association, although it is the condominium rider. So really nothing crazy there. A lot of wordsmithing in the non-developer disclosure section, whether the buyer acknowledges the buyer has been provided. When you're filling this out, that's the other thing I'm noticing too. When you're filling this out, please remember you're filling this out on behalf of the seller at the time of listing. So you're filling in this information. You would not fill in this section here about the buyer has or it's voidable. This is what happens when the buyer gets this and then acknowledges it, whether they've received it or not. Excuse me. And also the buyer's request for documents. It's really important that the seller understands that they have a responsibility, as do you, to provide the most recent forms. And I know that what ends up happening is somebody moves in, they live in a condo or some other association for a period of time, and they get updates, but they don't add the updates to their booklet, or they see the updates, don't print them out. So they give you an old copy. It's both your party's responsibility to make sure that you have the most recent copy of information in MLS or available for the buyer. If they find that they have an old copy, then the contract becomes voidable. You can see that we've gotten rid of the majority of the governance from. So it's the inspection report. This is related back to the inspections that are required now for properties that are within 3 miles of the ocean, and the assessments that may come along with that. So that's all changed related to the necessity and awareness of. And then I think that was it on the Condo Rider. So the major section that got changed is the maintenance inspections and the structural integrity reserve survey. Turnover inspection reports, the responsibility for them to return over those reports is or is not required. When those reports were done, most places were trying to get them done before the end of the year. That was extended and then pulled back. So lots of different things that they have to be aware of if you're within 3 miles of the ocean. Okay.
Do we need the covenants form any longer then, or and the coastal line addendums? Do we need those?
You still need the coastal construction control line, and that's a good point on the condos. The FAQ sheet, a lot of you have not been doing the FAQ sheet, and you're asking me why I'm asking for it, because it's a governmental requirement. So we do have a Florida statutes requirement. We do have to have the FAQ sheet. That's customarily filled out by the association themselves. Some of them are not very quick to do that, but yes, you still need the coastal construction control line. This is related to the inspection reports or any structural integrity reports that were done on the property, or that should have been done on the property, and how they were paid for, who has to pay for them. But you still need the construction control line, the governance documents, and the FAQ, yes.
But the governance form, the actual governance form that they crossed out, do we not need that anymore?
You still need that, yes. They've crossed this out here. You still need that as a separate requirement, yes.
Okay.
Yeah. Yeah, we don't need less, we need more. So always a challenge. Anything else about this one? Seems odd. Sorry? Okay. I did want to just jump into the listing agreement, since there was nothing updated on the listing agreement, just friendly reminders. This really is your marketing term. This starts our responsibilities as the brokerage and your responsibilities as the agent. The signature date starts the contract. This signature date starts the contract. So for example, if the signature date is today, which is the 7th, and I'm not going to put this listing in until the 12th into MLS, I need a seller waiver of entry. Because the way the rule works is that within 24 hours of the signature date, It needs to be in MLS. If I'm not doing that for whatever reason, photos, cleanliness, updates, whatever it happens to be, I need a seller waiver of entry. So if it's not 24 hours from this date, I need a seller waiver of entry. To reflect that I have a seller waiver of entry, I do need to select paragraph 6B. I need to select this box. Select this, let me do this. Select this box and have them initial. So if I'm not putting the listing in within 24 hours, I need to select this box and have them initial here. Do I have to remove the seller waiver of entry once we're ready to go live? No. Seller waiver of entry is negated by any public marketing. This means posting on MLS, posting in MLS, posting on social media, that negates your seller waiver of entry. But the seller waiver of entry needs to be reflected in the listing agreement by using paragraph 6B. So if you have a seller waiver of entry, you need to make sure that 6B is completed.
Can I ask a question?
Yeah.
I'm sorry.
No, good.
If you're checking off 6B and you're saying that once you go public, it negates the seller's waiver, that's not negating the fact that you check 6B, which means you cannot never display the property because you have it checked off here.
Actually, yes, it does, because it says it does not authorize the broker to display the property in MLS. So once you put it into MLS, that negates this section.
It does? It's
So
not
once you put
contradicting
it
that
in-
section?
Excuse me?
It's not contradicting that section if you have that checked off?
No,
Okay. I'm sorry.
no.
I-
Yeah, no, don't be sorry. That's good for clarification. So once you publicly market it, not only does it negate the seller waiver of entry, but it cancels this also because you've now put it into MLS. If you would like to have the seller then initial this, you can. There's no problem doing that. Or amend the listing agreement. Modify the listing agreement to reflect that it is now going public. You can do that. Compensation, please remember, we use our primary format is seller to buyer's broker. So A should reflect only what is being paid to the listing brokerage, ourselves, and 10 should either be B or C. In other words, what's being potentially offered. And here's for clarification. When you take this listing and the seller says, I would consider, or let me make it so it says the seller authorizes the broker to offer compensation to the buyer's broker to offer compensation. It's not saying guarantees compensation. Authorizes broker to offer compensation to the buyer's broker from the seller in the amount of X% of the purchase price or a dollar amount. The compensation will be set forth in a separate written agreement between the seller and the buyer's broker. That's that compensation agreement. So that tells us, well, not tells us specifically, but intimates that compensation, well, it doesn't intimate because it does say in here that the compensation is always negotiable. So if the seller is offering 3% at the time of listing, that's their intent at the time of listing. There's no guarantee of compensation. So if the offer comes in and it's not great and the seller no longer wants to offer 3%, the seller has no obligation to offer 3%. So when the offer comes in and the agent, and you've got it listed at $650,000 and the offer comes in at $500,000 and the seller says, look, I'll take $500,000, but I'm not paying 3%. I'm going to pay 0.5% to the buyer's broker. That's fine. The buyer and the seller negotiate that. Remember, the buyer already has a buyer-broker agreement which obligates them to pay the buyer's broker a certain amount. If the buyer's broker changes that between the buyer's broker and the buyer, that's up to them. But there's no guarantee of compensation. So whatever is in here is not a guarantee. So when agents, and we're seeing a lot fewer agents call asking about compensation, But it is okay to say to someone who calls, the seller was considering offering 2%. Please submit your offer with a compensation agreement, and the seller will consider all terms and conditions. But this does not mean, we had an agent try to argue that, well, you told me the seller was offering 2.5%. And our agent said, yes, they were offering 2.5%, but based on your offer, they countered back, reducing that compensation. Well, but they were guaranteeing. No, they weren't guaranteeing. They had said that they would consider this amount. So there's no guarantee of compensation. There's only guarantee of cooperation. Please don't forget to sign the dispute resolution related to arbitration and mediation. Had a couple of people ask about exclusions. Our market has changed a little bit, so can we exclude, for example, the seller says, my cousin wants to buy the house. Can we exclude him or her from the contract? You can exclude, but we will not accept an exclusion for any longer than 2 weeks. There's too much that you do to set up your listing and to begin the process and investment that you put into your listings. If someone is interested, this helps also push them forward to ensure that they take the steps necessary. Sorry, we have challenges here. Not only from Margot, but from Cooper. Anyway. Anyway, so exclusions won't be taken for any longer than 2 weeks. Anything else on the listing agreement that you want clarification on or concerns about? Anything else anybody wants to bring up about the forms, or what forms are necessary or needed, or that exists in a form or doesn't exist in a form?
I have a question, Clark. It's a little bit off the beaten path of what we're talking about, but the notification that came out that as of January the 1st, there are now new requirements having to do with the purchase and sale of condominiums. And there's a whole lot of language in there. Are you going to do a class on that by any chance?
I can.
That would be really, really cool, because condos are very challenging right now.
Yeah.
Since the collapse. And I mean, there's verbiage in there I've never seen or heard before, and I don't want to sit down and have to look up every single word or call the legal hotline and keep some poor kid on the phone for 15 hours. So if we could, that would be great.
So you're asking for a session on the Condo Rider itself? Yeah, sure. No problem.
Yeah, and all of those other words that I can't even recall. I didn't even write them down because I knew I was going to ask you about them today.
Yeah, that's fine. We can kind of talk about properties and where they're at, condos and what we need to do about them. Sure.
Cool, thank you.
Yeah, no problem. Anybody else want something you want to throw out there? Okay, I know that I need to check on personal property again, and I'll check on confirmation from legal hotline about 6B if we should add anything else or add any steps just to make sure. I don't mind checking and rechecking. And
the FF and GG on your cheat sheet. Make sure they're there.
okay, checking on those.
Sir. Thank you.
All right, anything anybody else wants to add? Questions, comments, concerns, opportunities? Happy New Year, everybody.
Thank you.
Thank you.
Yeah.
All right,
Happy New
guys,
Year.
thanks for, I'm going to go ahead and stop the recording. And if you're all good, I'm all good. And I hope you have a great day.
Thank you. You too.
Thank
Thank you.
Thank you.
Bye.
Bye.